community.
Ocala's information station, 1370 WOCA.
Ocala.
It's Wednesday, and you're hearing that music, and you know that sometimes John Fuller is in the courtroom, so he can't be live, which means you want to know what date it is here in the studio. It's a way for you to know whether it's a good time to call in. Well, if in your world it is October 16th, 2013, Wednesday, October 16th, 2013, then you're listening to a live show, and John Fuller is in the studio ready to answer your legal questions. This is his show. It's called Legally Yours, and John, of course, is an attorney with the law firm of Fuller & Fuller here in Ocala. The other Fuller is Janet Fuller, his beautiful wife, and we don't see her very often, but John is here. Good morning, John.
Good morning, Larry.
Where are you?
Good morning to everyone who's listening. I hope everyone is having a good day and enjoying this pretty fall weather that we have in this time of year.
It is nice. I love it in the morning. I love it in the evening.
Yeah, it still gets warm middle of the day.
Middle of the day, it's still like a summertime day, but we do have some phone calls already, so let's just jump right into some of these. Wow, you got them lit up. They were waiting for you. So last week it took
really makes me feel good. We have a lot of wonderful listeners who always are right up on the issues and have wonderful questions, and I'm delighted to have people take their time to call.
I have one little thing to tell you before we go to the call. Happy anniversary. A little bird told me 40 years?
Yes, on the 18th, I will have practiced law 40 years.
Wow.
And my judicial assistant has been with me 32 of those 40 years.
Oh,
and
wow.
So I'm very grateful for a wonderful staff. My wife and partner certainly make the practice of law, which is sometimes challenging, demanding, frustrating. It's an adversarial world that I live in, and it's a real blessing to be surrounded by wonderful people. And no individual is better than the team that he or she has around them. And I'm very grateful and very lucky.
The entire 40 years in Ocala?
40 years in Ocala.
Wow. All right, now let's go to the phone. I didn't mean to make anybody wait. Good morning. Thank you for being patient with us. You're on the air with John Fuller.
Good morning, Mr. Fuller. Always a pleasure to listen and talk with you, and happy anniversary.
Well, thank you. Thank you kindly, and thank you for calling in. It's always a pleasure to hear from you.
Well, the county is better to have you and your wife as attorneys.
Well, you're
both
just
really credit to this community, I must say.
Gosh, I appreciate that. Thank you.
I have a question. In regards to jury duty, I know of a person that was a convicted felon and was called to jury duty. And as a matter of fact, I think the person left this week is not even in the state. What happens when a person who is a convicted felon is called up for jury duty? I'll hang up and listen to your answer.
Thank you, sir. As always, that's a very, very interesting question about our system. And first of all, as you already presumed in your question, if you are a convicted felon, you are not eligible to serve on a jury. The way prospective jurors are selected is that if you have a Florida driver's license, it all goes into the computer and people are randomly selected from the list of Florida drivers in the area where the court is sitting. So there's not always a good cross-reference, and occasionally someone will be summoned for jury duty who has been convicted of a felony. And one of the first questions that they usually ask when someone comes for jury duty, they have a questionnaire, is, have you ever been convicted of a felony and have not had your civil rights restored? If you have not had your civil rights restored and you are a convicted felon, you are automatically disqualified from jury duty. They will excuse you from your summons, and you have no obligation to serve and no ability to serve because you're legally incompetent by virtue of being a convicted felon.
Wow, so that's it. You just tell them.
Yeah. Yes, and they normally do a screening search on that, but you know, it's difficult. People could have been convicted in other states. It could have been a very long time ago. It just didn't make it somehow into the database. So that's the first question that they ask. Now, if you're a convicted felon and you've had your civil rights restored, then you have all the benefits of citizenship that every other citizen enjoys, and the duties of citizenship, which is, of course, serving on jury duty if summoned.
The number to call if you'd like to speak to John is 622-9622. Just so you know, it is August 16th, 2013 right now, so that you know what date we're on in case you're listening to a rerun. There's a story in the news today about the arrest of, I think, two young girls, 15 years old, I think, or maybe 15 and 12. And anyway, they were bullying another girl. The other girl here in Florida jumped off the tower and killed herself.
I saw the headlines of that article, and I remember reading about it some time ago when the tragedy occurred.
Right.
That is, of course, a horrific tragedy. And it's a rather, I guess we've always had bullies in society, and that's just human nature, I suppose, to some extent. But what is really new for the law to come to grips with and to handle is evolving technology. We have so much social media out there where people can be viciously attacked in a rather anonymous way, or even in some cases not an anonymous way, and the whole thing is a real tragedy. And I see where an arrest was made. Other investigations are pending as to whether or not there will be more defendants, more individuals arrested, and whether or not there would be charges against the individuals who are minors, whether or not there'd be charges against their parents. It's the law is a moving, dynamic, changing force because society is a moving, dynamic force. We never had to worry about social media issues 20 years ago, or maybe even less than that. But as our society evolves, the law does evolve with it, and that's the beauty of our system, is that it's the precepts and the fundamentals that were established by our founding fathers have remained intact since the 1700s, but our society has changed dramatically. You first saw some of it when with the invention of the automobile. You didn't have a lot of horse and buggy accidents where two buggies ran into each other at an intersection. You didn't have red lights. You had so some of the very first cases that came out were the law had to change to accommodate when people started driving cars and what were traffic rules. A lot of products cases evolved with technology. The first cars were made with window glass, so that if you hit it, you could very easily decapitate yourself or bleed to death. There was no requirement for safety glass and that sort of thing. So as the law evolves, technology evolves, the law changes to try to accommodate that.
So this is a broad question I'm going to ask, but I'm going to ask it this way, and maybe I'll tell you why. Does precedence become law?
Yes. Well, precedent is a kind of a multifaceted concept. There is a benefit to having certainty and stability in the law. So if a question is litigated and an appellate court renders an opinion, that opinion sets a precedent for what the legal answer to that legal question is in that jurisdiction. And it is helpful because it allows citizens and their lawyers and judges to know what the law is on a particular topic. So having precedent is generally a good thing in that it establishes a constant thread that we will know how controversies and conflicts between citizens or the government and citizens are to be dealt with and interpreted, and how our laws are interpreted and applied. Having said that, precedent is not an all-controlling, all-consuming philosophy, because things change. And we have had precedent in the past that was the law of the land that was overruled, and the courts have the right to overrule their cases, and they do that from time to time.
And thank you for the answer. Let me go back to the phone. Good morning. You're on the air with John Fuller.
Good morning. I have a question. You might have talked about it before. I do a lot of off-road riding, and when you go to these off-road parks, they make you sign a waiver. And I'm just wondering, these protective waivers that they have you sign, how much weight do they carry? I mean, if somebody gets severely injured or dies, I mean, is that waiver enough to protect the owner of the facility? And I'll hang up and listen to your answer. Thank you.
Thank you for calling. That's a good question. Like so many questions in the law, there's not a clear-cut answer to that the waiver is the last word in something. Obviously, if you are a business owner and the public is going to come to your business and engage in some type of behavior that could be considered hazardous or subject people to the potential for injury, you want to get a waiver. The waiver is enforceable under most circumstances. However, not all circumstances. If the waiver and again, it depends, in a lot of cases, it depends on the language in the waiver. If you have a really well-drawn, drafted waiver, it can be quite extensive because there are a lot of different legal issues at play. But by and large, someone who is engaging in an activity that is sponsored or provided by a business person, and in order to be allowed to participate, they are requested to sign a waiver. Those things are certainly enforceable. There used to be a concept in the law known as assumption of the risk. It is no longer a theory that stands alone. It's been kind of absorbed into the overall concept of comparative negligence. But if someone engages in a hazardous activity voluntarily, there is certainly a legal precedent that they are deemed to have known the risk that they voluntarily undertook and to have accepted that risk. So waivers can and are valuable tools for business owners to have, and they are enforceable. Having said that, just because you have a waiver does not provide absolute immunity against all types of activities. If, for instance, there is a known defect that the land or property owner, premises owner, knows about and fails to disclose it to the people who buy a ticket to come to his hazardous activity, whatever that may be, the waiver may not be effective against willful or gross reckless negligence. And there are other exceptions. That's just one that comes to mind.
That's good news. That would make sense.
If it's something that you know, if you're running a carnival and you know that there are 4 bolts missing from the main support beam on the Ferris wheel, and you just don't take the time or the money or the interest to go and to put that thing together properly, even though you know that it's a potential death trap, and you have someone sign a waiver and they get on it and the thing collapses and kills a bunch of people, you're waiving a little piece of paper for a waiver. It may not be very effective under that scenario, and I think you and hopefully all our listeners can understand that.
Yeah.
So,
and that's good, actually. The phone line is open if you'd like to call John Fuller. The number is 622-9622, and the date is important because John is not always able to be here because he does go into the courtroom sometimes on Wednesdays. Today it's Wednesday, October 16th, 2013. So if you want to call John, this is a good time to get a couple of pieces of information that might help you understand the law a little better. 2 days short of celebrating 40 years as an attorney.
Well, it's been a joy to practice here. I consider being a member of the legal profession still a noble opportunity. I know that our profession is not perfect. But I'm always impressed by the motto of the National Association of Criminal Defense Lawyers, and that is that the criminal defense lawyer is liberty's last champion, and we've talked about that before. And it's a fearsome thing when a citizen is accused of a criminal offense by the government. Because the government is a very powerful organization. We have some very important protections that have been guaranteed to us by the Bill of Rights, but to see that those protections are enforced, the person who does it is the criminal defense lawyer, and they are often maligned by society. They are often criticized. It's always been somewhat amusing to me to hear people criticize criminal defense lawyers, and if an individual's arrested, he must be guilty. Why don't you just forget all this nonsense and go hanging from the highest tree? And I'm being not literal in that, but in any event, I have had the occasion over those 40 years to hear people make those observations and speak impassionately about the someone getting off on a technicality. It's always a technicality when the other guy gets off.
Right.
I have also seen those individuals when they or a loved one or a family member happened to be caught up and charged in the criminal justice system, and what was yesterday's technicality is now a fundamental right, and the criminal defense lawyer who was being maligned yesterday for trying to get a crook off is the champion that stands between the wrongfully accused individual and big government.
I'm sure you can think of lots of examples, too.
I can, and it always is amusing to me. And the system, as I've said before on this program, my dear friend and mentor, who is now 86 years old, practicing law in Georgia still every day. They base the television show Matlock on his life. Bobby Lee Cook, one of the finest finest trial lawyers in the state. When asked about that and the job of the criminal defense lawyer in society and why it was often a role that was easy to criticize and to be abusive towards people who did defend accused citizens, he said a great thing. He said, if the government can railroad a bad man, the government can also railroad a good man. In other words, if you can bend the rules to convict a bad man under the theory that the end justifies the means, you can bend those same rules and convict a good man wrongfully, and our system is based upon the premise that it is better for a guilty person to go free than it is for an innocent person to be wrongfully convicted. And I think with the evolving technology of science and DNA, there is no more eloquent argument than to look at the hundreds of cases throughout the United States where people have actually served many years on death row awaiting execution, and when DNA technology evolved and became accepted by the courts, a vast majority of those, or a vast number of those people were exonerated because it was established by later DNA testing of the original evidence that the individual who was convicted, many of them on eyewitness testimony, were innocent. And they were immediately released from prison. If they, the real problem is that if the death penalty had been applied and then they found the DNA evidence, it's kind of difficult to have a do-over when you have the death penalty.
I know, and I'm a hypocrite with the death penalty because I will say I'm against it when it's kind of an ambivalent topic, but when there's a specific criminal being charged, like in the news, and you read about the murder that he is found guilty of, then I'm for it. That's how I find myself being hypocritical.
Well, we are all human, and that is a very human reaction to have a dispassionate intellectual view of a controversial topic. But when it is personalized in some way or viewed, it's a different situation. But the biggest problem that I see with the death penalty is that it has not been able to be universally applied. And if you look statistically, the vast majority of people who are convicted and sentenced to the death penalty are from the lowest element of our society in terms of economics, education, opportunity. And if you can't apply it where it applies equally to all members of society, I think there's a pretty compelling argument that because there is such finality in the death penalty, that you don't apply it at all. Interesting thing came up is that some of the countries, most of our short-acting anesthetics and hypnotics that are used in surgery are now made in other countries because there's no big profit for making that for the American pharmaceutical industry, and several of those countries have laws that prohibit the death penalty, and so they refuse to sell the drugs to the American prison system to be used as part of the three-drug compound in lethal injection cases. Florida is just now having to change because they are no longer able to get the initial drug. When someone is put to death by the state, they have been using a three-drug combination for lethal injection. And
they just used a new one yesterday.
They did. They used Versed, which is a very powerful hypnotic tranquilizer. The theory of the first drug and the previous drugs that were used was sodium pentothal, and the other one was propofol, known as Diprovan. And those drugs were to put someone basically to sleep so they had no feeling. If anyone's ever gone to have a colonoscopy or something like that, they used to use Versed, and then they started using Diprovan. The generic name is propofol, and you're completely out of it. You don't remember anything, you don't feel anything, and so that was the purpose of that being the first drug in the cocktail. The two that they had done studies on was sodium pentobarbital and Diprovan. The state of Florida, for the first time in the first state, had to substitute Versed, and there's really never been any study as to how effective it is at blocking pain, because the next two injections that they give the person, one of them is a paralytic agent that paralyzes all the muscles, so it stops the diaphragm from breathing, and the third one is potassium chloride, which causes the heart to stop beating, and potassium chloride is an exceedingly painful way to die if someone injects you with potassium chloride. Our Constitution has a prohibition against cruel and unusual punishment, and there is an argument that has probably been made or will be made or is being made that until you can establish with some kind of scientific proof that these drugs are in fact functioning as they're designed for a humane execution, so you don't run afoul of the cruel and unusual punishment clause of the Constitution, I think you've got a real issue. And the individual who is being executed, the second drug they give him paralyzes him or her, so there's no way that they can cry out or display any kind of pain or anguish when the potassium chloride is injected. So science is an interesting part of that, and I just read that in the paper. And they've used this other cocktail of drugs, this 3-drug combination, and they've established that it was humane, and they have done tests. But now the countries that manufacture that drug will no longer sell it to the American prison system.
Oh, wow. Wow. Yeah, I'm torn about that. I guess if I was going to be forced to make a choice, I'd be against it and just figure out something else to do with these. I don't know. And then as soon as I hear a story, I'm going to be hypocritical and say, yeah, do it.
Yes. Well, I think you fit into the majority of American society. It's and maybe they are certain cases where it should be reserved for. But my concern is that if you are going to reserve it for certain cases and apply it, that you have extraordinary checks and balances to see that the individual who's charged and is facing that punishment has the complete best that society can offer them for their defense. And it's one thing when you have a defendant and the expert that they're able to hire has a master's degree from some less than prestigious school, and the government comes in with a PhD who's the dean of one of the Harvard science schools, or from MIT or Caltech or somewhere like that, because the government can pay him his fee, and the budget for the defendant is you end up with a guy who was in the bottom 10% of his class in chemistry, and he's going to try to come in and dispute and debate very complex issues.
John, if we need to get a hold of you, how do we get you? What's your number?
Our office number is 352-547-4292 at the law firm of Fuller & Fuller. We also have offices in the villages, and we have a toll-free number for the convenience of people listening out of our area. It's 855-534-2565.
All right. John Fuller, thank you for all you do.
Always a pleasure. Thank you, Larry.
Congratulations on 40 years.
Thank you for your kind thoughts.
We'll take a break and be right back.
Ocala's information station, 1370 WOCA.
Ocala.
ABC News Now. I'm Karen Chase. Senate leaders are scrambling to reach a deal to raise the debt ceiling and avert a default. They say they think they can do it before the midnight deadline. An airport employee is being held on $1 million bond and charged with planting dry ice bombs at LAX. Investigators say he took the dry ice from a plane and may have been angry over a labor dispute. 2 exploded. No one was hurt. A group of Haitian and Jamaican immigrants apparently trying to start a new life in the U.S. never made it. Their boat capsized off Miami. 4 of them died and 1 was hospitalized. They were rescued. A court case that began as an effort by a same-sex couple to adopt each other's children may become the first step toward rewriting Michigan's ban on gay marriage. A federal judge in Detroit the ban after hearing arguments in the case today. Now you have a scientific excuse for being unable to stop eating Oreos. Researchers found they can be as addictive as cocaine. A study found they light up the same brain receptors as addictive drugs. The culprit? Their high fat and sugar content. This is ABC News.
When we ran out, we stopped using it.
Why would you stop?
Why undo all the good that's been accomplished? We thought everything was fine, and that was not a good thing.
No.
He started stinking. It was awful.
Shedding comes back, loss of hair, lots of dandruff.
Scratching will return. His shedding will increase.
If I ever took Roy off of Dynamite, he would go back to his hair loss.
DINO.